for me that I would like to see is, and actually some of the books from here that do this, whenever anybody's asking for an interim distribution, it's normally to the IRS. You know, we're getting the motion out of the loop. Certain percentage of those motions don't get granted just because there's either not enough money in the estate, or it comes when they made their final payment, your client's calling you saying, hey, it's hard to pay the IRS. And generally, my request to the judge is essentially don't make us do two closings. You know, it's going to, if we have to pay that IRS claim when we just received all the money, and then wait for that check to clear, it's just ultimately delaying the closure of the entire case for all other creditors. So in my opinion, it's not very fair to the other creditors. But, you know, a quick call to us, we can tell you, yeah, we have enough money there. You know, I'm not sure that we can necessarily file that on negative notice, but, you know, it's something where a certain amount of those motions are not getting granted, and you probably could save time by just giving us a call and letting us know that you're anticipating it. The other thing,
we could probably sign consent too, I think,
yeah.
if it was.
I think it has to go out on notice to creditors, probably, and maybe that's something that could be added to the negative notice list. I don't know why it couldn't be.
And, you know, the thing is, we're not opposed in many instances to it, but if I had to give a percentage, it's probably 50-60% that are not getting granted, because it's either the case is really ready to close at that point, or we don't have enough money to pay the claim.
And I wouldn't have a problem with an agreed order that said parties in interest have 21 days to object.
I get you.
I think the issue from the trustee's perspective, or certainly from mine, is that the U.S. trustee discourages interim distributions that don't follow their procedures. Obviously, I know what our court's position is, and I don't personally have a problem with it, but I don't know that.
And I think they're back, the U.S. trustee's office, or have anybody know?
No.
I think is backing off of that
Okay.
position a little bit because of the bank service charge issue.
Okay.
I think they're much less opposed. They used to be horribly opposed to interim distributions. I think they're much less opposed now. But you know, if you're holding, if the trustee is holding monies that's going to go to the IRS anyway, and it's hurting the debtor because the check's not going, as long as the trustee's holding enough money to deal with admin claims and everything else, I certainly don't have a problem with it, and I'm glad that the trustees generally don't.
Yeah, and I think, again, the U.S. trustee's concern is utilizing their procedures in their review. Now, I prefer our procedures personally, but
Well, their procedures being what? Their review of
they want like an interim final report and a proposed, you know.
Not for IRS stuff, though.
Well, they used to object. But
I think they backed off of that.
Next item I have is just exemptions, a couple of issues, and many of you may know about the website. There's a website called Exemption Express. And generally, as trustee, I use that site to determine whether residency might be a requirement for using a different state's exemptions. They have like a click-through type of procedure where, for instance, Montana, they probably got lots of bankruptcy there. You know, it'll have a click through right through their website as to personal property exemption, whether it seems like you have to be a resident or not, and also real property. So I found that to be fairly helpful, and it seems to be kept up to date pretty well. So
Wes has an exemption manual too.
But I'm sorry.
Wes has an exemption manual
Okay.
with a table for all states, and then and also a nice summary of the law. It's expensive, but it's.
Well, this is a great free resource that's published online by a law professor, and it's certainly what I use too. Not only does it have the chart, but you click on where it says yes or no, you click on the box and it'll give you a case citation.
Or it'll bring up the actual statute.
That's this
You're
one.
talking about the same thing, Louise?
Exemption Express, the
Yeah.
same website. It's an excellent free resource. I wouldn't cite it to the court, but it gets you started.
Yeah, no.
The other thing on exemptions, and again, other people who are not here probably do, it's a pet peeve, of course. If an exemption is supposed to be a dollar amount, that's normally what I'm looking for, not necessarily a percentage amount. And sometimes I feel like they're looking for us to drop the ball type of thing, where somebody's saying, I want 100% of it, and if we don't object, of course, it's an allowed exemption. So if it's supposed to be a dollar amount, I would certainly appreciate everybody abiding by putting a dollar amount in as opposed to a percentage. And I think the last thing, and I think most do it, whenever there's amendments to B and C, of course there's a local rule that provides, that we indicate what's added, what's deleted, but what's not very, well, it's not really stated in the local rule, but I think actually Miller and Hollander does it. We do it, even a notice, not necessarily on the B and C itself, but on the notice, and it's not required, but they'll put what's being added specifically, what's being deleted, what's being changed, so it gives us a little less time to be figuring out what's being changed.
And also, I'm not sure if it's mandatory, but it would be helpful to restate or see when you add something, because I don't know that that's mandatory, but what we see sometimes is somebody will add something and they may add one piece of personal property, and we don't know if that's intended to be in addition to all the things that were on the original B or amended, or if you could restate the entire C so we can do the math, so we can make sure that the number, and you can make sure that the numbers are correct.
And I think the local rule
It requires
when you amend A, B, or C, that it be an amended complete schedule. When you add creditors, you don't need to file an amended schedule D and add, or F and add additional creditors. But for A, B, and C, you need to have a complete list so that the trustee or the court or creditors only need to look at the most recently filed schedule in order to see everything.
Also, don't, when you have a joint case, husband and wife, put their exemptions together with Mark Lawford. It honestly, it makes it easier. I don't know, there's probably some sort of button in there where it can put them together as opposed to splitting them out, husband, wife. That makes it more difficult. Last thing for me, if anybody's asking for excusal of a debtor for 341, under the circumstances, I don't necessarily have any issue one way or another as long as it seems reasonable, but make sure you bring the Social Security and ID, the debtor who's actually appearing, because we still need to look that over.
It's not appearing on.
Well, normally it's in a joint case where they're asking for one to be excused, like we had one this morning. The only thing I'm asking for is you got to bring me an original of their Social Security, so I have something to look at, because that is not necessarily being excused.
I thought I'd just open it up to questions from the floor. Do you all have any questions for us? Yes, Brian.
If you have a homestead underwater, and let's say you don't claim the homestead exemption, but you want to keep the property, are you still trying to sell the properties? Are there still companies out there willing to give you $3,000?
Every day of the week. What we do in my office is that there was a custom report that was prepared by Epic. I guess it's custom, but our software vendor that pulls out all the Schedule A data and the Schedule C data as it relates. And that report gets set to our folks that have asked to be on our auction list. And so we email that out weekly. And we receive bids. I think that my office, we're probably filing one a week or one every other week. Folks are still buying these. I'm personally filing a motion to sell under 363B and listing out all the costs that are being paid in order to deal with objections from the Florida Department of Revenue. I'm also ensuring that the deed's personally recording the deed and paying any documentary stamp taxes associated with it and recording costs. So that way, all of that is noticed to creditors. It's all approved by the court. It's all paid through the estate. That's how I'm handling it in my cases.
I'm actually getting separate checks to the clerk. I actually say, okay, here's one check to the clerk for the doc stamps and the recording costs, and that's what they have to provide. And then for the monies that are going through the estate, then I have a separate check for that, because I don't want to have service charges or anything else get assessed on the doc stamps and on the recording costs, and our trustees' fees arguably could be calculated on that. That's not the point. The point is to make sure that these things are paid properly.
Short answer is we're still receiving bids from people interested.
Now, I'm very, you know, I will tell you, from my perspective, I really take a good look at what the cost basis was of the property, because obviously I don't want to create a tax consequence of one of these underwater sales. Because technically, if you have $3,500 plus a mortgage that's essentially being assumed, and the basis of the property was much lower, I don't want to have a capital gains tax or have a tax of some sort generated by virtue of my sale. So I make that judgment on each case when I get an offer. So.
In addition, I actually receive offers I don't accept sometimes, and just
Yeah,
because the
you do too, yeah.
possibility that it's just really not going to create any real money for creditors. So, but to the extent, and sometimes it happens where you have it might say $150,000 of unsecured on F, but when you go look at it, it's 120 to
Some
BAC,
deficiency,
home mortgage that
yeah.
never files a claim, never does anything. In that type of case, I might actually accept the offer just because the possibility that they're not going to file a claim. So, but if you have 200,000 of just credit card people that always file and somebody's offering 3,000, I'm probably not doing it. You know, it's just not going to create anything.
I will tell you right now, and I've heard this when I was talking to the U.S. Trustee's Office recently, I think some of this litigation has made some creditors gun shy about filing cases. About filing claims. And even though a Schedule F might have, 200,000 in claims, I've had cases where I get $1,000 of creditors' claims. So it's it's a different environment in terms of who's filing claims these days. A lot of the deficiency claims are not they won't even file a claim. So it also affects, when you talk about small administration cases, $3,000 and $4,000 cases may end up paying 50 or 60% dividends to unsecureds because of the fact that some of these mortgage creditors are not filing deficiency claims. So it does affect our judgment on what cases we'll administer and what we won't. Any other questions? I appreciate those people who get appraisals in advance. I know that's, in a lot of cases, it's not necessary, but I think it's a good protection for you all. Because, again, it's like the case where there's equity that doesn't appear to be equity in the real estate. Then they're not coming back and pointing at you and saying, why didn't you tell me? I had a case, I don't know if it got sent out yet, they list, maybe $500 of jewelry, and I get the appraisal back and it's $7,000 of jewelry or something,
Or they got a $20,000 grand piano.
Yeah, exactly, so.
And just talking to Joy and Gwen about it, they prefer it too, because, it's not under duress, you're voluntarily going in and you're establishing a time, so they prefer having it done prior to the filing rather than at the trustee's direction.
Well, I think
Prices
that's
are bad
Well,
sometimes.
it's easier to get paid too.
That's right.
Well, we pay, I pay to the trustee.
Well, no, I understand that.
Yeah.
I'm just saying that they get paid.
Oh, at the
We
time.
always send out
Yeah.
Joy every time because, you never know when they're gonna have that $20,000 grand piano or antique or
Well, and also,
whatever.
there's the endowment effect. The people that have stuff think their stuff's worth more than it really is. And that's a
I've had that
proven
happen a lot,
economic, it's
too.
a psychological function.
Yeah,
So you avoid that.
and actually, I just because I send them out, sometimes I'm guessing wrong too. Because I don't send them out in every case. Sometimes I'll say, well, that seems reasonable and I'm not gonna do it. That's why 341s that I conduct, and I know these guys probably do too, that's why I ask about how old your TVs are, how big they are, how many TVs do you have. If you got 1997 appliances, and you've got no TVs, and you got, you know, the
Usually it's about the size of the
2005
house.
Vista computer, you know, I'm not gonna go waste the estate assets out to get an appraisal. But on the other hand, when you find out that they have an engagement ring that they, oh gee, I never thought of that, and, you know, it's got 3-carat diamond or something like that, you know. And you've heard those stories, which I've told you about, the, you know, oh gee, that jewelry that was, you know.
My grandmother gave it to me. I said,
Pardon?
it's still yours. Well, I get my grandmother gave it to me, and I go, it's still yours.
Yeah,
Now it's
exactly.
yours.
And, you know, we get a lot of that, you know.
They wouldn't hide stuff from you.
Or the
Oh,
debtor
I'm
that shows
sure
up
they
to the
wouldn't hide it.
341 with a Rolex.
Pardon?
Or the debtor that shows up to the 341 with a Rolex.
They don't have
Oh,
two
yeah.
L's in
Longer
that.
the city of New, you know, the streets of New York, when you're talking about it.
Yeah, I mean,
2 L's.
it is interesting, and the stories we get are interesting, that's for sure, so. Anything else we can answer?
Thank you.
Don't forget the dinner on October 15th. I'll email out more details in the coming week. Again, Judge Delano and Chief Judge Williamson be our special guests, and they're making a special trip. So,
And also nominations for secretary and for the professionalism award. And Judge, you're a member of the association, so you can nominate as well.
All right. That's mine.
Okay.
I'm gonna put these on the table, on the desk. You wanna go eat?